2021, around 19:55 p.m. at Sophia's house, with Melissa for a thought and lawful cause death of Sophia Bisaka by stabbing her body with a 7-inch knife. Also slicing on her chest, Jasmine, and depriving her from breathing and caused her death.
Speaking English.
Okay, both language. Whatever the language the court prefers.
Information has been read to you that on 20th November 2021, around late in the Morogoro municipality, you have been accused of killing, murdering one Sophia Bisaka and Jasmine. Do you agree?
No, Your Honor.
Your Lordship, before you is the case of murder concerning the accused called Breaker, and I pray before your court, the Honorable Court, that justice to be observed as this case concerns the death of...
Answer, please. The court does not know you. Who are you?
My name is Leading Counsel Thomas Asheri. Your Lordship, as it pleases you, may I introduce my fellow prosecutors that I've been accompanied with.
Dear Judge, State Attorney Alexander Mzumbe.
It's please assume your lordship and Advocate Humphrey Sharon.
It pleases your lordship. My name is Shabani Hamis Echato.
It pleases your lordship. My name is Jonathan David, State Attorney.
Dear judges, my name is Joshua Marcia, State Attorney.
If it pleases you, Your Honorable Judge, I am Donatus Kaangwa, State Attorney. We are accompanied with 2 witnesses plus 1 exhibit. Dear Honorable Judges, I pray before this court to observe justice as the case is concerning about the death of 2 innocent people, leaving a child.
Counsel, hold on. You have said that you have 2 witnesses.
Yes,
And the 2?
and 1 exhibit.
And you are ready to proceed with the hearing. Yes?
Yes, we are ready.
Accused, are you ready?
Yes, sir.
Call the witness.
Anyama. Person who could have committed a crime with such occurrence. And at that time we were also accompanied with police and this. Okay, and he would have been unemployed. So, and after that, we tried to talk with that young 3-year-old child of the deceased one. He told us that he tried to describe to us.
May you repeat your last testimony?
From the beginning. I said that the psychologist told us that a person who could have committed the crime could have been either a sexually repressed person, a person in the age of 20 to his a person who would have been at the age of 21, 20s, and up to 30s. Yeah. Look at such nice and it could be a person who is very superstitious because of a part of the body that was cut from the Sophia's body. Yeah, and the deceased was stabbed with something which has pinched, something with sharp instrument. And the girl was the little girl who was dead also. He had stripes on his neck, something like someone is suffocating her. And his lower body, it was not covered his words. So after then, we tried to speak with the little boy who was 3 years, a son of Sophia, known as John. And
you said you spoke to the child, isn't it? What did he say?
The child told me that he saw the accused person. That's
So?
The accused. He saw the accused person.
Then after?
Then after that, we tried to communicate with the police artist and the owner of the psychologist, so that if that child he could have remembered in the art, well and good that he tried to describe the person. So the police artist had to go with a sketch. And after we had known that sketch, then we went out with the investigation.
Okay, then after you had all the sketches and other details, what followed as an taking responsibility?
After that, we went from house to house to try to talk and interrogate with people who are that involved, that if we had shown them that sketch, that if they could in any circumstances at around that time, or if they could have identified that person. And what was good is that among we had interrogated like 30 people, and after we had interrogated 30 people, and said that this man was calling the car.
Do you tell the court how many people identified the accused?
From the sketch, there are 4 people. Yet, what? Then after that, we went and arrested Corin Wecker. And during the process of arresting and the interrogation of Corin Wecker, we had also got a phone call from Areni who said that he saw Corin Wecker on that day. And at that time, he saw Corin Wecker on the day and at around that time when there was occurrence of murder.
Detective, for the benefit of the record, may you just remind the court who identified the witness as you said in the interrogation?
There was a witness, a woman, who had called us. I reserve his name. Who had called us and told us that he saw Corin Wecker around that time in the area of Village, and it's mentioned that it was around the neighborhood where the crimes of murder occurred.
Statement that is brought forward, the child is not involved in any form of identification in relation to this crime. The child is only mentioned as being the only person that was present while the crime was committed. And what they found in relation to the child is that while the police officer was present in the crime, when they went to the crime scene, they only found the child crying on his mother's body. And there is no any other statement that involves any identification that was made to involve the child and the police officer. So all statements that relate to identification in relation to the child is highly inadmissible and is new fact that is brought to this court that was intended by the prosecution in their written statements. Thank you, Lordship.
They remind this court to revise the 8th page of our written submission.
I failed what to answer, but what is relevant for us is a document which has been filed before this court. Unless you refer to us, what should we have to refer? You have a caution statement, you have other documents which have been filed with us. If you pass the pages, okay. But written submission is not part and parcel, because even if we have not reached there, we don't have it, right? So the prosecution side proceed, but restrain yourself from the demarcation that you have been.
First, I don't know if I'm allowed to continue to interfere, but that's what I wrote in my caution statement. That is what I wrote in my caution statement, and we were told that they were pre-admitted.
Counsels, please speak to your witness. Once the court says something, you have to abide. I hope you understand that.
Allow our witness to refresh. You conducted a search.
You had conducted a search.
So if there are any item or anything that you acquired from the
Lordships of the court will once counsels one or other stands up, the other has to sit. Is a review. Sit.
Your Lordship, counsel prosecution is providing you questions, and we ask this court that this question be reported to court.
Sorry?
The question asked by the prosecution is a leading question asked by section 151, subsection 1 of the Evidence Act, and therefore ask that this court remove this question from records to court. 150 and 151.
Prosecution side.
Your Honor, I heard this opinion being ordered. I think it is relevant to continue with what has been located by the defense counsel.
Provide that any question suggesting the answer, section 150 of the Evidence Act, Legislation 2019, provides that any question suggesting the answer which the person putting it wishes to expects to receive is called a leading question. And the question, the provision that is cited by the counsel of prosecution to justify their statement, subsection 2, section 151 of the Evidence Act, provides that the court shall only admit such questions when they are introducing any facts. And the question asked by the prosecution counsel was if the witness did any research, and that question does not introduce anything but suggests the conclusion to imply that the witness in their professional duty did or did not do something in relation to this case, and therefore it is a leading question. The witness is replying to the exact leading question that we say should be struck out.
counsel, you are the one to direct the witness. As per what you are speaking, I know that you know the procedure. I'm going to tell you that you do this, at least you will cry, and then you move right.
Yes. To tell the court when you have received the information about the commission of crimes, when you go there to the scene of crime, the day you receive the information about the commission of crime.
After of the crime had already, as I not explained about it, we went and investigated, and still we had involved various interrogation, and we had received various calls. There's one among the call was the call from Instagram, a girl who was chatting with the
Evidence Act provides that Section 62 of the Evidence Act provides that all evidence that is produced by a witness in oral testimony should be produced only by evidence by a person who has seen, heard, or was present in the commission of the offense. Therefore, any evidence that is produced by the witness in relation to any person who is not herself at the time of commission of crime or to her personal knowledge should be struck out as hearsay evidence. Thank you.
Section 34B. Section under the Law of Evidence Act give a circumstance in which a person can give us a statement of other witness testify before the court. You may refer that section.
Your Lordships, I remind you, this is the court of law. You don't have like that.
If I may proceed, Your Lordships. May I read the provision of section 34B in which counsel for prosecution is relying to in relation to statements of the same? The provision says, when the statement was made, when the statement was made by such persons in ordinary course of business, in any particular, when it consists of an entry or memorandum made by him in books or records kept in the ordinary course of business, or discharge of professional duty, or if acknowledgement written or signed by him of the receipt of money, goods, security, or property of any kind, or of the date or later than the document usually dated. The provision of these statements, Your Lordship, unless he was referring to any other section 34B, does not in any manner relate to the circumstances that are present today, and therefore is a wrong citation of the provisions of the law. Still, the statement remains to be hearsay evidence. Thank you.
Okay. How it help you to know and to arrest the accused person?
You see it?
Provision of the law that in any circumstances, Section 62 provides that the witness can only testify on anything that relates to the facts in which he or she witnessed. And evidence by the psychologist, any evidence that involves any document or any involvement of any other witness apart from the witness.
The court has already ruled that you have a room during your final submission.
after we had drawn the photo picture of the accused person, of the suspect person, we went and asked various people during interrogation, and after asking, there was 4 people who had identified that it was Colin Quicker. And after that, we had arrested Colin Quicker, and we had sent him, we tried to interrogate him, and still he denied that he wasn't the one who had committed the crime. Then after that, we allowed him to go out of there. But still, we had sent our agent, that's a secret agent who had gone there as a girl to approach Colin Quicker. and had asked her various things, in which he said that he had asked that if he would have committed the crime of murder, that he had killed he had killed Sophia Bisaka together with his daughter. Still he denied that he was the one who, he said this, that he is interested with other violences, but to say the truth, that he did not commit that crime. So due to that, the interests, and if you connect that these interests of violences that he had said, together with the psychologist reports that a person could have committed, the one who is interested in such kinds of, that is a person who is interested in such kind of maybe offenses, sexually pressed, and still as he had approached that, and still he had approached and the Instagram caller, all of them, they said that he was a person who was calling out for sex. So he was as you connect those things, that made us to rearrest Colin Quaker.
So, after the arresting of accused person, what have you do? What as a police officer, what will you do to prove the accused person he had commit that offense?
Brought him before the court of law so that the court can be what? If he's the one who is not there. After we had arrested him, due to that evidence that we brought him before the court of law. We brought him before the court of law so that the court can decide.
Yeah, witness. Which you have anything to tell the court related to this case in order to prove this case?
More than what I have provided, with nothing else.
Thank you, Honorable Judge. Defense answer, procedures.
This court today, are you rebutting that statement right now?
I'm not rebutting that statement since you're the judge. I'm not a witness.
Okay, so what you're saying is you did not see any more evidence
that I interrogated. So I stand here as an inspector. I'm not as
Thank you, Your Lordships.
For how long have you been a police officer?
10 years.
So you want to assure this honorable court that you have got 10 years of experience on your job?
Yeah, of course.
Well, on the incident, the day that the incident occurred, can you just give a brief summary on how you got the information and how you reached to the crime scene?
How I got the information is from the OCD, who had informed me that I should go to the place that allowed me to, there is murder, there is occurrence of that crime.
Your Lordships, it is rule of evidence under section 147, section 3, that in re-examination, no new facts be introduced. And right now, the witness is telling us about information about the OCD and all this process that he did not himself validate in examination in chief or cross-examination or in his in-her own witness statements. And we ask this court to remove these facts from record. Thank you.
Prosecution side.
This person has got no mandate to move from his or her home to the crime scene without an order. So, I just asked that in order, your honorable court, to verify the steps taken and the information where this inspector got and what steps did. I pray before honorable court to hand me agree to the question asked about the OCD, as the OCD is the one who gave orders to the inspector to visit the crime scene. The inspector is not God that can just move to the crime scene without any information from someone on top of her. I pray before this honorable court to admit.
Your Lordships, I believe, leading counsel for prosecution has not yet read the wordings of section 147, section 3, which provides that the re-examination shall be directed to explanations of matters referred to in cross-examination, and does not provide for any other matters that were referred in any other parts of the proceeding. Subjection is only to any information that was provided for in cross-examination. And any new facts it provides, and if new facts is by permission of the court introduced in re-examination, the adverse party may further cross-examine upon this matter. Therefore, we pray to this court that if you see fit to allow the prosecution to continue in this phase of introducing new facts in relation to the OCD, may you give us, we pray that you give us chance to cross-examine the facts saying this particular examination. Thank you.
Prosecution side, you must be aware that the defense side, the counsel for defense side, has a concern which this court also sees there is a substance in it. So as a matter of fact, if we request you to constrain yourself with the functions of the examination.
Dear witness, said you went to the fence, right?
Yeah.
After reaching the crime scene, what circumstances did you observe over there in connection to what an accused has done?
The circumstances that I observed were that there was occurrence of murder. There was occurrence of murder where there was 2 people who were murdered.
Well, so at the crime scene, you found 2 bodies. And what can you tell the court about the circumstances of the 2 bodies? How did they look like?
One was stabbed, was something that is injured, and the other one was just lying in bed. And it has some streets that say that like he was suffocated.
Well, at the crime scene, did you take any measures as to start an investigation?
Lordships, we have understand that the prosecution. Okay. The Lordships, the prosecution against the rule in examination of witness that provides that no leading question be allowed in re-examination. Leading questions are only allowed in cross-examination. The provisions of section 151, 151, and 152 provide for only cross-examination, that the leading questions are allowed and not an examination in chief or re-examination.
Your Lordship, the question asked is indeed a written question, but to the matter that is stated as before this court, I pray before this court to refer the records about what she stated, if she stated it earlier or not.
Which record?
The ones you are taking. As during the examination in chief and cross-examination.
So, please, this court is in dispute with the questions that being reasonable. So the matter is, as it has been raised by the counsel for the prosecution. So you have to reply to what the counsel for the prosecution says, not referring to us to what you have read.
Having any dispute?
Your Lordship. Your Lordship,
Counsel for prosecution, please. What we, unless otherwise you allow us to do otherwise, but we give you an opportunity to reply what has been said by the counsel for the defense side. That's your right. So we give you a right and you are, I don't know, what can I say? So are you replying to it or restrain from any further questions that you are doing?
About the question asked earlier.
Tell us, what do you understand section 151 in relation to your questions that have been tell the points.
Section 151 provides for the leading questions that are not allowed before this court. May I read before you? Section 151 sub 1 states, a leading question shall not, if objected by the adverse party, be asked in an examination in chief or in a re-examination, except with the permission of the court.
Okay. The relevance of that?
The relevance of this is that the questions which show some impacts of as leading to the witnesses are not allowed before this court.
So what do we invite us to do?
I invite you to observe the previous answers and the question that the witness provided.
We urge that this court give them no permission to ask. It should be sought before an act is said or done and not afterwards. Thank you, Your Lordship.
That you found two bodies.
Of course.
Were you able to identify?
Your Lordships, but despite our court giving ruling on the use of leading question in re-examination, it seems the counsel for prosecution still and persists on ignoring the orders of this court by again asking leading questions. We therefore ask that this court take any legal measures against the counsel for not adhering to court orders. Thank you, Mr.
Question, I asked the same question to this witness and replied that at the crime scene found two witnesses. I've repeated the same question after the dispute and the defense counsel is saying that a leading question. She replied it prior.
If I may, Your Lordships, the provision of section 151, subsection 1 only says that the leading question shall not, if objected to be by the adverse party. It does not provide me any time or any space in which I can notice a leading question. I spot a leading question at any time in which the counsel for prosecution provides for leading question. I have noticed the leading question, and therefore I am at liberty in section 151 to raise the concern of leading question, which provides shall not, if objected by the adverse party. Thank you.
Find the bodies that you found there.
Now we are able to identify them.
How do they look like?
Prosecution side, proceed.
Your Lordship, despite continuous repetition on the concern of leading question, again, prosecution is still again asking another leading question, which right now is not previously stated. So we now dispute the fact that this question is a leading question should be struck out.
Thank you, Your Lordship. I'm humbled to stand before you. I am of the merciful report that this honorable court is read to administer justice on the case that is at hand. I will please and pray this honorable court.
Please remind the court may hear.
Thank you, Your Honor. I will please, as far as for the sake of justice is concerned, and for the provision of Section 151, Subsection 2, that will provide for the court to permit leading persons as to matters which are introductory or disputed, or which have in fact opinion been already already sufficient enough to allow us, please, to ask the person that was asked by leading counsel so as to build proper case as far as the section that I've stated is concerned. So please, Your Lordship, may you have that permission before this court. Thank you very much. Please stand by the provision of 151 section 1. That was his reply goes by, as I stood, goes by section 151 section 2, and the same also I humbly ask and pray before this court to allow the same person so that we may have something good established following the cross-examination that was done by the defense counsel.
Dear witness, after informed what happened next as a police officer who has got 10 years of experience.
As a police officer, after we found the bodies, we tried to check there if there was any evidence that we could get and help us in our investigation work, but we did not get any evidence. So we decided to consult a psychologist.
You said that as you found the bodies, there was nothing on proceeding the investigation, right? What efforts, after you found that there was no anything that would be connected to the offense, what efforts as a police officer did you do in order to ensure that the lives of the innocent people and their rights are sustained before this honorable court?
We had drafted various fit photo picture, which were two of them. And after drafting the photo of each picture, we had conducted an investigation period to every house, in which we had tried to conduct about 30 people.
So you made the efforts by taking the fit pictures. And how was that helpful? How was that help investigation?
Because they are the image that the person saw at that time when they are in the crimes. From the description of the psychologist.
Your Lordships, the counsel prosecution is introducing new facts that are not present in filings of the witness that is present in court. All facts of the relation to pictures that were used in investigation of what is in the witness statement. And as per section 147, subsection 3, which provides for re-examination, such facts shall only be introduced, shall not be introduced in cross-examination. If such facts are introduced, we seek for this court that we cross-examine the witness in relation to such facts. Thank you.
Your Lordship, this is not a new fact to this case. In examination in chief, the witness said that he moved from the police station to the crime scene. I call upon this court that to admit the question asked prior that what circumstances and what efforts made as a police officer having a 10 years experience do. When, for the sake of justice, I pray before your court to admit the questions which were indisputed by the defense counsels to proceed.
The city and let me, before I give that,
you had an ample time to make an interview with the neighbors, about 30 men. That did you observe to all of that large number of people?
Among the things that we had observed is that there are people who had identified Colin Quaker as the person who had put on that occupation. And after that, we made a thorough investigation where we did not get anything, we did not get more clarification.
About 30 men you did an interview, right? So it seems that like there's the efficiency of your work. That means you're efficient enough to understand how to do the investigation. So in 30 million neighbors those, what did you observe taking that time? What did you observe from those people? Or it was just a waste of time?
People identified that it is Colin Quaker, and we had taken him to the police station where he had learned that he wasn't the one. And thereafter we had sent a secret agent to investigate, and there we got an input and evidence that could be used for further investigation.
So, 4 people identified the accused as Colin Quaker, right? Well, and on your side, have you ever any relation with Colin Quaker? Or have you ever met him somewhere?
Unless after he was a suspect, there's nothing else that I've ever met him before.
So you want to state this before the Honorable Court that you have no any relationship with the accused, right? Your Lordship, I reserve questions for now.
When you other matters, if you think that you will not be understanding, you may reserve them.
So I humbly use your orders and
orders. Chapter 16, revised edition of 2019. After following all the preliminary procedures, the accused pleaded not guilty. Then the full trial were conducted before this honorable court, whereby the prosecution side was given an opportunity to present their defenses to the allegations. And this was upon going through the evidence of reports from psychologists as well as the information that were given by the witness, which he claimed to have been obtained in the course of the investigations. And all of the evidence were pointed the accused person as a person who had committed the same offense. Upon such an analysis and the deliberation of this honorable court have found that the accused person has a case to answer. Before this honorable court, the accused person, you are informed that you may either defend the case alone or if you have any witnesses. So please tell this honorable court, will you defend yourself or will you bring any witness?
I defend myself.
I defend myself. Okay. So the further procedures to be followed by the registrar this one.
By Almighty God.
That the evidence I shall give will be the truth
will be the truth
and nothing but the truth.
and nothing but the truth.
Witness, you're reminded to be slow and audible so that the court may record.
Examination of the witness. Dear witness, may you tell this court what is your name?
And they say my name is Colin Quicker.
And may you tell this honorable court how old are you?
I am 31 years old.
And also, can you tell this honorable court where are you living?
I live at Wambi in Morogoro region, in Alban, Morogoro Alban Municipality.
And your occupation?
Entrepreneurship.
Objection. I'm raising this objection as to previously stated. Under Section 147 Sub 2 of the Tanzania Evidence Act has stated that in chief, the examination in chief must relate to relevant facts, but the cross-examination need not to be confined to the facts, Your Lordship. The defense counsel are still trying to introduce facts which are irrelevant. The occupation of the accused is unemployed and not self-employed. I call upon this court to overrule that question.
Being employed in its literal meaning means being subjected to duties and conducts of an employer. And therefore, being self-employed also means that you have no subjection to any employer, which is exact equivalent of being unemployed. And we have no, and by the way, the provision that he read, section 147, subsection 2, provides that the prosecution, the examination in chief must relate to relevant facts, which is exactly what we are trying to establish, the occupation of the accused person. It is saying
Prosecutions, don't give us the back.
Thank you, Lordship. I would like my fellow defense counsel to tell us, at least in what authority he construed himself, saying that the meaning of unemployment is as equal or it equal.
Okay. You said you exercise by walking.
Yeah, with my dog, yes.
After you passed the eating areas, what was the time when you crossed the eating area?
I say here, 6. I mean, at 12 p.m. I say 12 p.m. Don't forget that.
So, as 31 years old,
yes.
Why are you not married after now?
Is that the personal question? I can never answer.
You never answer.
Is that a personal question?
Lordship, I reserve my question.
In court. Sawa. Teach yourself, lakini this how happened. You may sit. I know the main intention of this exercise was to avail to us, all of you, what transpires always in the courts. Sometimes lawyers do so, which will be a very najua ni kipindi ambacho watu wanakwenda na wengine wakitoka pale pale appeal nini na vitu kama hivyo. It's always a fight. And it's very enjoyable when you begin the journey of going to court. And when you accomplish you wish to see who won. But the court at this time has a different opinion. So I welcome my colleague at least to give an observation what has transpired in this. Kama kuna vitu vya kurekebisha, vitu gani ambavyo tunakwenda kuvifanya, kwa sababu aim yetu haikuwa to make competitions. Aim yetu ni kutesti baadaye huko tunapokwenda patakuwaje. Sawa? Alafu tukiita sasa tunasema this is the competition, tujue sasa watu mna observe vitu gani. Kuna vitu vingi sana ambavyo tumeobserve and we wish you to understand them, to rectify Mr. Rashid, to address what he has seen during all this process. I beg you at least to take note or to take care. At least you know what to be done.
Okay, thank you very much.
Sound system, please.
First of all, as you know that we were making just a moot trial, how things are transpired before the court of law. So the procedures that we were supposed to undertake was we were required to follow all the procedural rules of criminal trials and courts. As you know, when accused person is plead not guilty, the first step is to take PH, but we skip it. That's the reason why we're doing it, is because the rule of the game assumed everything was done as in order. So that is why we skip the PH stage and we jumped into the hearing stage. So in hearing stage, as you were doing here, involved those examination of witnesses, and which actually you know, there is examination of guilty, examination, cross-examinations. You confine yourself to only asking the question that will try to either build your case. Or if you are a prosecutor, make sure you ask the question that will try to build your case. And how do you know that? Make sure you ask all questions that if they will be answered, the fact that will be given, the testimony will be relevant to the fact you want in the issue. So that is the thing which you have to observe. And when you cross-examine, make sure you confine yourself to only facts that were, the only testimony that were given to the what? To the witness. You are allowed to ask the question which is not relevant to the fact in the issue. But if it implicates some issues which are going to destroy the evidence which was given, that might be accepted. No? But whenever question you are asked, make sure you know the purpose of it. What is the purpose of asking such question? Are you intending to destroy the evidence, or you are just asking that question? Even if it is relevant, it is relevant, but the purpose is not an important thing. In re-examination, you all know the rules. Na kitu kingine, I think I want to share an experience with you ni kwenye reply objection. Reply objection ni mbona kuna tatizo. Sawa? Mwenzako anaporize concern huko, wewe unamjibu. Jibu kama ile tunafanyaje? Aliuliza. Kwa mfano, labda huyo ameraise this issues is standards. Wewe unapokuja reply correspond to the issue. Make sure that you confine yourself to what he has asked. Kama ni standards, provide argument that states that the question was not standards. Alafu huyu anasema it is standard. Sasa sio unakuja hapo na introduce another new issue. Sio kitu kizuri. Kwa hiyo kwa mfano huyu standards, wewe unapokuja at least una make argument kuonyesha kwamba the question was not standard that you are responding to his argument, unless labda unataka kuadmit the fact ambayo amefanya ile objection ambayo amefanya ame-raise. Sawa? Alafu kitu kingine ambacho hii ni substantive issue kwenye kuchagua shahidi. Hili swali mtego wake mkubwa, kama nilikuwa makini, ilikuwa ni kuchagua who is a proper witness. For prosecution as well as for defense. Kuna witness, there are a lot of witnesses there. Kuna fact ni issue. Kuna fact ni issue. The question ambayo ilikuwa initially, sindio? So, the fact kwamba kuna mada ipo, sindio? Kuna possession of death ipo. Mali safari tukiangalia hizi fact were there. Huyu mtu aliyeua alikuwa intended man. He intended to kill. But who actually did it? That is the question ambayo ilikuwa mbele ya nini? Ama kama ulifanya kujibu. Sindio? Kwa sababu criminal liability is always personal. Sindio? Sasa kwenye zile exceptions nyingine kama corporate kesi yake, sindio? Lakini kwenye criminal liability mara nyingi ni personal. So who actually did this one? Nani aliyefanya? That was the question ambayo kwenye hii. Hata issue yetu ilikuwa ni whether Mungu friend naona alikosea, labda whether huyu nani kweka alimada just women and mwenzie. So ushahidi wote ambao utakuwa uletwe hapa ni ule ushahidi ambao utapoint out nani Colin kwamba amefanyaje? Amefanya hicho kitendo. Sasa ushahidi wa nani kati ya mashahidi wote waliokuwa hapa huko more accurate kwenye point out na mtoto tayari alishakuwa excluded kama nilipata fact vizuri kwa sababu alikuwa in coma, so he cannot be called to testify. Na yeye ndiye alikuwa ni so obviously is not a potential witness in this case. So then woman ambaye alikuwa ni mwana jamaa connected alimwana ongelea what the fact in the issue. Mwana tunaongelea exactly the process that kwamba yeye ndio kwa kama kwamba hili mwana anaongelea nini matupu ni safakimisha. Kwa hiyo kwenye hii scenario neighbor alimkuta mtoto. Sindio? Ambaye alikuwa
first of all, I would like to congratulate you on what you have done. Of course, you have done well. I congratulate you. As long as we were in the matter of learning, I've observed, I myself, some of the things that were contrary to the court procedures. I would like to recommend you one of the things. The first thing, it is the purpose of making re-examination. You have to make sure that once you want to re-examine a witness, you have the purpose. You want to destroy which thing? Which evidence are you going to destroy it? After the other side has made a close examination. That means when the other side is making close examination, you, the other side, you have to make sure that you are making follow-up on the questions which are being asked. Looking on whether those questions which are being asked, they are destroying your case. Thereafter, you can identify those insecurities. After then, you can draw some of the questions that you are going to pose in the re-examination. So as you can make clear and discredit the presence or the evidence which are being discredited during the cross-examination. Tunaelewana? Kikubwa ni kujua unauliza swali kwa mnaenda verify, you are using a lot of time, na rudi tena kule kwenye story. Hapo unakuwa tayari haujengi chochote, kwa sababu unakuwa rudi kwenye zile narration of the story. How discredit au destroy kila ambacho mwenyewe amefanya nini? Ameenda kukidispute. Now, kama mnavyojua, as per evidence rule, huwa tunasema the fact which is being tendered, if it is not being disputed, that means we presume it is existing. Si ndio hivyo? Kwa hiyo maana kumbe lazima tuangalie hicho kitu. Lakini pia kitu kingine ambacho nimekiona kwenye examination in chief, tulikuwa tunajikuta tunauliza maswali ambayo ni randomly, hayalengi kunareti story ya kesi yako zidi ya kuvutia upande wako. Kwa kumbe timisi maswali ambayo unayatengeneza ambayo ya kumguide yule witness unapomuuliza, lazima yawe maswali ambayo yana build your case, yana narrate, yanatengeneza coherent, lakini huku kiu unavutia upande wako. Kikubwa tu kiangalia usi-introduce new evidence. Hapo tunaelewana? Hicho ni cha pili. Lakini kingine ambacho nilikinote, witness unajikuta anakuwa hayuko guided vizuri, na ndio maana inafika sema anashindwa kuijenga kesi yenu. Facts zinakuwa zina head. Wewe yule leading counsel unayemuuliza, unayemuongoza pale, kumbe wewe ndio unatakiwa umguide maswali yako, umuulize ajibu kulingana na maswali uliyomuuliza. Lengo kiu unalenga kupeleke wapi? Huku kiu unawaza kwamba upande huu hata kama wakiwa na cross lazima wakutaki cross examine. Huku kiu unajua mtakuja kufanya re-examination. After saying so, I would like to thank you. I would like also to emphasize you making more practice, all of you. I don't mean on one side, so as we can create good lawyers, not only theoretically but also practically. Huwa kuna msemo Lodineni Mwara alishawahi kusema, sikumbuki exactly the case, alisema if he wants to win the case, he has to know how to play with his witness. Thank you.
Thank you very much, Mr. McCoy. Do we have any staff member around from either coordinator, from Mzumbe, or let me wind up. I know we had a lot to, we saw by ourselves what has been done through all this process. I too observed a few things that I wish to convey to you. Tunapokuja mahakamani kwa wakili, kazi kubwa ni kujua taratibu za mahakama. That's one thing. Sawa. Taratibu za mahakama. Mfano, how do we address the court? That's very important. I heard some saying, dear judge. How do we address the court? How do we address the court? Yeah, yani uwezi kumwita kama dia wako, sema dia sijui ilikuwa na maana gani, lakini we have to know what language we use when we go to court. So, address properly. Kwa sababu the way you display yourself, atajua wewe how serious are you about kwenye hii matter ambayo una present. So that's very important. Kingine, how do you hapa tuweka tu kama makusudi, namna gani unaweza you address the court always, address witness. Kwa hiyo mara nyingi unapokwenda mahakamani, kaa in such a way kuwa unamuaddress nani, you address the court. Sio mahakama unaipa mgongo alafu unakwenda unaongea unapiga story zako, mwingine huko anaacha. Nilifurahi sana, kuna mmoja alikuwa na wakati ana allow judges waandike. That's very important, very good remark. Mtu anapokuja ana allow, basi unaona na kama judge aandike unamwambia please this is irrelevant, andika. Kwa sababu ukipigwa utakata rufaa na ushahidi kama uliongea hapa hajaandika, hakuna rekodi, maana umeshapigwa. Kwa it's very important. Kwa hiyo kwa maana hiyo, maana hiyo inakwenda hatukimbizani pale, nenda taratibu. Sawa? Hapa hakuna mashindano ya kuongea mahakamani. Ni mashindano ya kuhakikisha unapeleka ujumbe wako kwa kiasi gani. Sawa? Kwa hiyo sio unaenda kaa cherehani, mwisho wa siku mimi sina nani kichwa cha tape recorder kama nani Kasuku. Kwa nitarudia baadaye hicho unachokiongea na mimi nirudie huko. Hapana. You have to go straight, kitu taratibu. Niambie mahakama. Usiende kwa haraka. Niambie mahakama, maana majaji wanaandika hichi unachokisema. Sawa? That's very important kwa sababu mwisho wa siku it's a record, ndio kinachokufanya umewin au lose. And if you lose, mwisho wa siku utakata rufaa. Kama haiko kwenye record, utaenda in any appellate court hivi tutareport. So that's very important when you want to become a good lawyer, you want to become a good advocate, you want to know that how do you pray with it. Vingine ambavyo tulikuwa vingi wameviongea, niliandika karibia vitu kama 16 ama 17 ambapo I said that they are very relevant. Vingine matumizi ya sheria nilikuwa nawakumbusha. Mwisho yake nimeona accused person anajibishana tena na mtu ambaye kwa sababu yeye umekuja kumhoji. Alafu mwisho wa siku anakuuliza swali na wewe unajibu. Sio kazi yako. Tumia sheria, Law of Evidence Act imeeleza kila kitu. Procedure yako ufanye nini? Kwa hiyo tumia sheria. Ndio maana nakwambia tumieni sheria. Mimi umpire, mimi siwezi kukufundisha fanya nini. Sawa? My duty ukiraise issue niambie, nitakuuliza una ground ipi? Kwa sababu ni sheria tujiweke kama sheria inaruhusu au kama kuna amendment juzi imefanyika, accused anaweza au witness anaweza kabishana na wewe. So you give the court that kuna sheria fulani inasema hii au sheria utaratibu inatoa hii. Kwa hiyo naomba tu. Ndio maana tunakaa hapa mimi tunabishana au tukikubaliana tunatoa ruling. So that's how the court does. So we should not take it for granted kwa sababu na kesi. Pili, amekiongea very important that kesi mara nyingi wanamsemo wengi wanasema the case is won in the chambers. That's very, nafikiri mawakili to be mnayajua haya. Huwa ukiona kesi hivi ukiangalia ISP. Sawa? Kwa ukiangalia nature hii kesi, afu kwa bahati mbaya sana tuliambiwa tulete shahidi huyu. Yaani ukiangalia mkisoma kule shahidi alikuwa ni huyu. Tulikuwa tunataka kupima pia uwezo wenu wa kujua shahidi yupi akiletwa anaweza akatoa cycle nzima ya kueleza kuwa huyu ndio aliyefanya hivi. Sawa? So that was an exercise. Kwa hiyo namna ambavyo mashahidi wameleta, hata tungekuwa tufanye ruling au tufanye judgment, ingekuja kusuggest manake tulikuwa tunachotafuta ni kitu gani, au mahakama ingekuwa inataka kujua interest. Kwa sababu kwenye kesi za mauaji it's a very prime case, kwamba mahakama kitu cha kwanza inajikataza, hatuwezi kumhukumu mtu kwa mada kesi kwa sababu mada kesi ina attract tena mada, si ndio? Kwa sababu punishment kubwa kabisa katika penal code ni death. Kwa hiyo kama huyu ana uhai tayari, maana una invite mahakama hii imuue tena, si ndio? Lazima uiconvince mahakama kuwa kuna kitu ambacho. Kwa hiyo connection ile chain ya ile ndani tulikuwa tunaitafuta, it should be kuwa inakuja mwisho wa siku ina suggest vitu kama hivi. Sawa? Kwa hiyo my point is bado tuna mambo mengi ya kujifunza katika maisha, hasa ya kuwa wanasheria. So we have a big journey to travel through. At the end of the day we come up tujue. Kwa hiyo tupitie hizi sheria, hiki kina nini kidogo sana, Law of Evidence, lakini kina mambo mengi mno. Sawa? Kwa hiyo I urge you learned fellow kuwa sometimes in the future muwe mawakili na wazuri. Alafu kitu kingine ambacho nimeshare na wewe, really cancel na wewe. Jamani, mawakili huwa wagombani. Sawa? Au wanasheria hawagombani mahakamani kwa sababu ya mteja. Sawa? Sisi tunachokwenda kuprobe. Sawa, we probe. Lakini mwisho wa siku kesho na kesho kutwa mtakutana kwenye kesi nyingine ambayo unaweza kumwomba bwana, hold for me a brief time. Sasa kama ulishagusha ngumi kwenye kesi ambayo wewe sio kesi yako, kwa sababu sio kesi yako, anayefungwa ni yule kule mwisho wa siku. Wewe unakuja uhangaika unataka kupigana na mwingine. My point is we are friendly. Sasa ni marafiki. Na kama katika urafiki wetu lazima udumu. Ndio maana tunaita lady brothers and lady sisters. Kwa sababu mwisho wa siku tunatengeneza kitu hiki lakini we build the profession professional. Sawa? For you, that could be my comments. Unless otherwise, I wish you a very nice journey throughout your studies, that one day you become good lawyers in the markets of United Republic of Tanzania. Kusema hivyo, tumeshinda wote, eti? Karibuni jamani, watu ambao kwanza wameingia hapa Mzumbe, karibuni Mzumbe. Naweza mkawatembeza marafiki, waweze kujua. Tuna Rosaria.
Imani ya baridi sana. Kwanza niweze kutoa bwana kwa pande zote mbili. Counsel for the defense pamoja na counsel for prosecution. Kweli mko na kazi nzito lakini mmejitahidi sana, kwa hongereni sana.